and other issues relating to data, in the sense of copyright, privacy, watermarking, bias, and so forth. And the way I wanted to run it this time, a little bit different, I guess, than yesterday, is first of all, give each one of you, maybe including you, because you've already spoken for an hour, 3 minutes to introduce yourself and say something about like what keeps you up at night in terms of LLMs and the subject of this panel. Shall we start with you? Please introduce yourself.
Hi. I'm Di Yang. I'm an assistant professor in the computer science department at Stanford University. I work on natural language processing and computational social science. In other words, I care about both large language models and people. And my research can be summarized into a few dimensions. First is around the bias and the fairness. So we have been talking about how amazing large language model is. The problem that I care about is who get represented in the process. There are a lot of factors that are not modeled into those big models today, such as around culture, social norm, vulnerable populations, low resource language, dialects, etc. So part of my goal is how could we deeply understand all those bias representation issues in those models, and then how could we mitigate those issues so that we have more responsible technologies. The second part is as those models are getting more and more impressive, despite incapabilities exist, we do see like amazing applications of how they can actually affect society. So in other aspects, we are also exploring how we can leverage large language models to empower individuals in very high stakeholder scenarios, such as in mental health and in many other domains. That's 3 minutes. Thank you. Yeah, thank you.
I'm Jonathan Frankel. I'm chief scientist at a small startup called Mosaic ML that I guess was just bought by a bigger startup called Databricks. I train large language models and other large generative models for the public. I release a lot of open source models, but my real business is that I build the pipeline so everybody can train their own custom models. So if you told me you wanted a custom ChatGPT 3.5 on your data for your business case, that's basically what I do. I'm coming at this from a couple perspectives. One is that I do spend a lot of time in the law and policy world. I technically once had the title of adjunct professor of law. I don't know anything about the law, but I hung out with a bunch of lawyers. So this is something near and dear to my heart. The other is that I really don't want to get sued. I have to build these models very frequently, and I don't want to end up like my friends at Stability. No offense if there's anyone from Stability in the room, but I really don't want to end up like you. So it's something that, I think a lot about not just what does the law say, but what will the law look like in a couple of years? And not just what will the law look like, but what could it look like? There's getting sued and winning, but there's also getting sued. And that's not fun, even if you eventually win. The other thing, just since Shafi mentioned it, I don't know why everybody thinks the sky is falling and that we're running out of data. I don't know where people get that from. I got plenty of data, and that's just the public data. Every company seems to have as much data internally as I get from web scrapes. So there's plenty of data. Just because you can't go and download it for free doesn't mean it's not there. So I'm not really sure I fully understand why everybody thinks the sky is falling on that front.
My name is Dong Song. I'm a professor in computer science here at UC Berkeley, and also a co-director of a campus-wide center on responsible decentralized intelligence. Actually, just a little announcement for the people who are here. Everybody here is really interested in LLM. So actually on August 27th, so about a week and a half, we'll actually have a summit on Berkeley campus on the future of decentralization, AI, and computing. And Shafi actually will be giving a keynote there. So for people here who are interested, you can go to the RDI website to learn more details, rdi.berkeley.edu. So my work is actually in the intersection of AI, machine learning, security, and also decentralization. Yes, so of course, it's a really exciting time. So first, I'm really concerned about responsible AI. So essentially, as the technology advances so fast, then at the same time, there are lots of challenges. So recently, we actually did a comprehensive evaluation for these LLMs in terms of the various different aspects for trustworthiness. You can also learn details by going to decodingtrust.github.io. And the evaluation really illustrated the huge challenges, open challenges in, on one hand, these models are so capable, but on the other hand, they still, have all these issues, toxicity, adversarial robustness, and privacy leakage, and fairness, bias, really broad range. So the question is, on one hand, as the technology improves, naturally we have the tendency that we want to use these models. But on the other hand, then how do we ensure that these models actually, when they're used, they don't cause more harm? And another thing that I'm really concerned about is, especially with this generative AI, now, of course, all the ad agencies and so everybody is utilizing these technologies. So in the future, there will be these really targeted, personalized, these AI-generated these contents that can target individuals to manipulate individuals, perceptions and so on. So on the other hand, we don't have good technologies to really protect individuals. And I think this attention-based economy can just get, much more challenging given the
Yeah, hi, I'm Scott Aronson. I'm a theoretical computer scientist at UT Austin. I'm on leave for 2 years now to work at OpenAI on foundations of AI safety. And one of the main things that's been keeping me up at night has been the problem of how do we make the outputs of AI models identifiable as such, for example, via cryptographic watermarking. And this is because, I needed a problem, that was a sort of an actual, social problem or misuse caused by language models, for example, right now. But also one where, there could be amenable to a technical solution, and where, theoretical computer science in particular would have something to say. And there's not a whole lot in the intersection of those requirements, but, the problem of how to watermark is one of them. I think that we've made some progress on it. And now there's there's the challenge of getting the different AI companies to coordinate on a solution. If anyone is interested, I'll be giving a talk about it tomorrow afternoon. Now, regarding copyright in particular, I mean, we all just heard what an actual expert sounds like. No one would, mistake me for that. Although, I might tip off the legal people at OpenAI that, there are some very, plausible lines of defense that we just heard in Professor Samuelson's talk that, they might want to take, maybe with fair use, But one thought that I just had listening to her talk was, we've been talking for several days about, this sort of just academic debate about are language models, just stochastic parrots, or are they really creative? And it occurs to me that this is like a case where this how we feel about this actually matters in practice. Because if you think of a language model as just a stochastic parrot, right, then you might say, well, it's parroting all of this copyrighted work, and it's, supplanting the market for it, and it's doing it without permission. That seems very unfair. On the other hand, if you think of it as just, an artificial version of a human brain, then you would say, well, I'm allowed to go to the library and read all of the books, right? I'm allowed to, come up with my own original works, inspired by what I read, right? And so I think that the academic debate actually sort of ties into the legal one in some ways.
But AI doesn't have any legal status,
Right.
unlike person.
Right.
So one thing actually that I think is really important in what you said, what you just said is worth commenting on, which is metaphors make a huge difference in the law, okay? Especially when you don't understand what's going on. So years ago, there was a big lawsuit between Apple and Microsoft, and also between Lotus and Borland. Some of us remember those. And metaphors won those cases. What I mean by this, when the trial judge said that the graphical user interface issues before the court looked like an automobile dashboard, the case was over because automobile dashboards are not protectable by copyright law. So the metaphor of that, now Apple had these really creative people designing all this choreography and blah, blah, blah. They tried to, make it seem like, this is just like cartoons and, and creative kind of stuff that's interaction and blah, blah, blah. Court said, looked like a dashboard to me. Okay. And in the Lotus v. Borland case, it was the analogy to the buttons of a VCR. Okay. So this issue that you just raised about, is it a stochastic parrot, leads in the direction of infringement, and the other metaphor leads to, it's independent creation. So metaphors are something that you guys play around with those, and you use words that sometimes lawyers basically say, you shouldn't use that word. Okay. So memorization, for example, right? You guys have a word for that. Okay. Memorization sounds like copyright infringement to a copyright lawyer. Okay. At the ICML conference, we were hearing about how important pre-training is. And it's like, pre-training is not the right word, okay? It's not the right phrase, if in fact that's the really important part of the development process. And so pre-training kind of sounds like, just assembling the little stuff that you do before you do the real stuff. And so metaphors are really super important. And so here are the lawyers basically, don't use that word memorization because it has all this ramifications. Anyway.
But going beyond metaphors, so the question really here is, what do we believe? And I think as a community, that word is not, we're not clear on this. Are these models really understanding and coming up with new understandings, or as you say, it's a brain that has new insights, or are we just how do you say it in English? Regurgitating or parroting? And I think that's a technical question. I don't know if anybody wants to.
I feel like in cases where you can point to a specific work that was substantially infringed by the output of a language model, or they're basically the same, or like if you have a copyrighted book and if you can ask the language model just sort of passage by passage to reproduce that book for you, right, then maybe the copyright holder of that book ought to have some recourse, right? But if it's just generalized, this data got fed into the maw, right? Then that feels more to me like, well, when I read a book, it has some effect on the synaptic weights in my brain, right? Some diffuse effect that of course influences everything that I do from that point forward, but maybe that's just covered by fair use. And then that feels more to me like at that point you want to change the law, right? If you want, there to be, if you want that to be illegal, then you want a new and different copyright regime. I don't know.
So you wanted to say something?
Yeah, I think to some extent it's a little bit unknowable. I think if we're predicating anything we do in our understanding of what's happening inside these models, we're going to have a very bad time. Maybe this is me being kind of an extreme empiricist here, but we don't understand whether humans are just stochastic parrots at the end of the day as well. And a lot of my looking at GPT-4 has made me feel like, wow, if we think this is human level, then maybe we as humans are not as smart as we think. So then you get philosophical very quickly, and you get to the question of what is an idea and what is originality and all that good stuff that I leave to the lawyers. So I think the real question for me is going to be if we do treat this as strictly a black box, if it is just looking at inputs and outputs. And I think what Scott said makes a lot of sense on that front. I don't know if we're ever going to get to the level of understanding where we can draw a line between is it a stochastic parrot and is it actually doing something more sophisticated.
I agree with what the other panelist said. I think one thing also is maybe we need to change the question that we're asking. So obviously, as we can see, it's not just regurgitating, it can create new things. And also the question of understanding, even like we don't even have a good definition of what it means for human understanding. I think the whole community has thought about this question for a really long time, and we still don't have an answer for that. I think what we are seeing is, as we know, we are creating this alien technology that somehow it has these new capabilities. On one hand, these new capabilities can help it to solve quite a lot of problems that's hard for humans. But on the other hand, we know that also it can make really silly mistakes. So I think what we are recognizing is that this is a completely new type of technology that we have, and we have no understanding, not much understanding of, and we have never seen anything like this before. And it can continue to improve, and it can improve faster and faster, and it can improve by itself in the future as well. So in some sense, I feel we need to start asking a different question: is what this technology can really do, where it can lead to, and what are the pitfalls and what's its limitations, and not just trying to do the analogy with humans.
Yeah, I have 3 keywords to share. First is understanding, and then comparison, and also evaluation. So I think understanding is not a binary construct. We all agree. It's a spectrum. Even for humans, it's really hard to see whether I really understand a skill, let's say co-reference resolution or mathematical reasoning, right? It's really hard to define it. And I think when you make the comparison or make the story around the GPT-4, whether it really be smart or not smart, I think it's really important to keep in mind who or which human group we are referring to. I think the GPT-4 is probably much better than me in solving those puzzles, right? And then, but who is the group we are going to use in the comparison here in terms of writing poems, in terms of solving mathematical issues, etc., etc. So that's like the reference point when we think about, when we mention understanding here. The other thing is that whether they really understand text, I think so far it always comes to how we evaluate them. And the evaluation is always like we use what we know to evaluate the models. So if you look at our evaluation procedure, we have benchmarks. Benchmarks are produced by humans. So we are evaluating models using the knowledge we know. Maybe they are producing a lot of creative original content. We just haven't found a systematic way to justify it. The space is huge. I don't think we have done enough to kind of explore what creation, what originality or novelty means. And then if we have ways or devices to achieve that, then maybe whether they are stochastic pairs will be answered to some extent.
So I want to follow up on something that Don said about it's the wrong thing is to compare these systems to people, and we should have sort of a different. It's not like a person that we're trying to match, and talk about scale. So I guess you talked about fair use, and that I guess it was designed in a different area to talk about things which are much smaller scale. And what do you think are the principles that we should follow when we update the policy for an era where the scale is so much larger? We're talking about so much more data and so forth. I think it's important.
So I'm not sure in 2 or 3 minutes I can do something, say something particularly helpful here. And this sounds like something that would be better to have a longer conversation about. I do think that that norms are going to be evolving in this space, and that the kind of policies should evolve with the norms, and there should be conversation about what those norms ought to be. And right now, a lot of the way that the norms are kind of getting created is through licenses that people basically slap on data. I had an interesting conversation with Joey Gonzalez about, hey, what kind of license should we slap on the data that we're using to make for training? And people are just slapping licenses on it, and they don't know what really the license ought to be. And so this is another fruitful place where lawyers and technologists might actually work together to come up with norms. One of the things that makes open source work is that you can claim copyright in the code that you write, and then the copyright gives you a hook to then be able to license it either open or in a proprietary way. But if you do it with the open, then you can enforce that openness. If we're talking about data and a compilation of data that isn't creatively selected and arranged in the way that copyright considers to be, right? If you're just throwing out bad data, that's not creative in the way that copyright cares about. So a lot of the data collections are probably not protectable by copyright law. Therefore, you don't have any intellectual property right in it. And if you don't have any intellectual property right in it, how can you possibly use, there's no hook for a license. And so if you respect the license, it's because it reflects a norm that you're willing to follow, as opposed to it's something that's legally enforceable. So a lot of open licenses really are about norms about sharing, right? And I don't want this particular kind of use of my thing. I'm making that a condition of you're basically agreeing to its openness. But the licenses may not, in fact, be enforceable.
I'm curious to kind of maybe rephrase Shafi's question a little bit. I think one of the interesting things with any technology is that it makes it much easier to do something that would have taken a lot of work and had a lot of cost in the past. In this case, maybe it makes it easy to infringe at mass scales in ways that might have been more difficult in decades past. And I know in my very minimal time hanging out with lawyers that there is a big question of kind of what is easy and what is hard, where is there friction and where is there not. And there seem to be fault lines in technology and how we, think about policy and regulation when that level of friction changes substantially, or when something can be done in a mechanized way that could not be done in a mechanized way before. I'm sorry to make you be a stand-in for all of legal scholarship, Pam, but I'm curious if there's any concept of that floating around where, infringement has become much easier in some way, and that
Yes.
changes our calculus.
Yeah, it's really the example historically is photocopying, right? There was a long time agreement that if a scholar or someone copied something by hand, that wasn't an infringement. And then early development of reprography technologies made kind of icky copies, and nobody really complained about that. There was what was called a gentleman's agreement between some scholarly people and some publishers that basically making copies under that technology was okay. Then Xerox comes along, and all of a sudden you have really high quality photocopies, and publishers went nuts. And there was a whole bunch of lawsuits and stuff in Congress. And bottom line was, because it was higher quality, because it made it so much easier, it had to be infringement, and therefore that it had to be licensed. And so that's an example where something went from being really hard to do to really easy to do. And the law eventually, at least for commercial copying and for at least course packs. Remember course packs? Course packs is something where that had to be licensed. Right? That was an easy way to make a new compilation that would displace the books that the publishers were selling. And publishers said, hey, we should get some money. So the permissions market basically developed to address this. So that's a historical example.
Do you think that diffusion models, for example, or generative image models represent enough of a change in the difficulty of potentially infringing that we may have to look at it differently?
Just because something's easy and something's more efficient doesn't mean that it's necessarily illegal. So I don't want to say that the efficiency and the sort of ease and the speed necessarily makes something more illegal. But it is the case that there are going to be people making those arguments, and that's why we're having this conversation, because this is not an easy problem to try to solve.
I want to pivot to another question, and then we're going to open to the audience in about 5 minutes. So there's a big connection between copyright issues and privacy. And in particular, I guess there's a lot of methods for differential privacy specifically out there to achieve something that seems very related to copyright. Now, so the measure is that whether you participated or not participated in a data set, it's indistinguishable in some sense. Of course, we know, I think a lot of people here know that all the differential privacy methods introduce also error, lack of accuracy, and so forth. So any thoughts about the fundamental differences between copyright and privacy, and or what's missing in my comparison? Anything to say about it from any of you?
I've thought a bit about this. So, I mean, I feel like differential privacy as it stands is probably not, applicable to large language models because, it's about, calculating, statistical averages, right? Or statistical information about a large population where, you don't want to be able to infer things from that about individuals, right? But with large language models, it's as if we have, this sort of exponentially large space of possible texts, that could have been written, right? And that's very, very sparsely populated by actual texts. And when you see them, of course it's going to influence, your output in a way that could violate the guarantees of differential privacy. But having said that, I think there are creative ways of dealing with this. So Boaz Barak and others have have had an exciting idea recently, which is that you basically divide your training data, you randomly divide your training data into two halves, right? And you train a separate model, on each half. And then, whenever you get a prompt, you see whether the logits, so like the probability is the same, according to both of these models, right? And you produce an output, only in cases where it's where both of these models trained on disjoint sets of data would have given you comparable probabilities. And then you have a defense against anyone who says, well, this relied essentially on my copyrighted work, which, well, no, well, this other model that wasn't trained on the work at all, had an output with a similar, would have had an output with a similar probability. So, yeah, I think, that's been prototyped a little bit, and maybe something like that would eventually be a solution.
So I think you wanted to go next, and then you don't.
Yeah. So first, I kind of second Scott on this. I think differential privacy is really hard to be applied to large language models, and especially given that a lot of the data we are dealing with are kind of unstructured. So it's really hard even to kind of identify what is sensitive data. Like SSN phone numbers are easy to specify, but there are lots of other type of informations, like maybe someone's religions or maybe someone's hobbies that they don't want others to know. And this kind of also introduce another kind of thing that we always ignore. I think for everyday users or ordinary people, the consent whether I want to give away my data is kind of unclear in most cases. When we talk about pre-training corpus, I think artists or scholars may have a louder voice in terms of defining whether my data is represented there, but like for majority silent. I think it's really hard to sort of tease out the consent issue here. Another thing happening here, I think, is also about it's really unclear what the data has been used today. It's really hard to track what type of data get involved or transformed in this process. It's not only just like in the pre-training stage or in the output stage what happened. So I think this kind of tracking or observability of how data flow into the process is another thing. If we want to do something like privacy preserving, we need to pay attention to. And in terms of methods, I think we need to be more creative. Like in addition to what Scott mentioned, I think something more like from an attack, a defense perspective, like how could we train models more at the downstream side, not at the pre-training stage in terms of how we can guarantee privacy is some quick thought.
Okay, yeah, I'd like to clarify a few things. So first, I think we are discussing several different problems or concepts. So one question is whether you can apply DP to LLM, large language models, and there's a separate question whether this actually helps with addressing copyright problems. I think we need to differentiate this two. So first of all, of course, you can apply DP to large language models. You can do DP SGD, and you can apply the same to, for differentially private training any of these neural network-based models. And the goal there, so then the question is, what do you get there and what's the difference to copyright? So the goal there is not to solve the copyright problem.
Right.
So our earlier work, we actually did one of the earliest work in the space, showing that one, so the memorization actually was particularly popularized by our paper earlier, showing that these language models actually they do actually remember a lot, and also you can have these very effective attacks that can extract sensitive information out of the original training data, including social security numbers and credit card numbers and all these things. So the paper actually won the Privacy Enhanced Technology Award, Run-Up Award, actually this year. And there we actually had, we proposed a measure actually to particularly measure the degree of memorization. So that's actually a metric that you can measure and evaluate. And then later on the follow-up work we did also extend this to even large language models and so on. So there we actually show that if you train differentially private language models, it actually can help address these issues in solving this type of problem, in protecting these extremely rare sensitive data in the training data set. But however, as Shafi mentioned, so these techniques, it's difficult to scale to really large language models, and also it gets more expensive. And in general, actually in practice, people don't try. But I think, so first of all, more work is needed there. I think we can definitely try more. And to develop more effective methods there. But separately, that problem, that technology doesn't really address the copyright problem. So the copyright problem, also as what Scott mentioned, you divide this data into two, but actually the copyright material can be embedded in the training data for many, many times. That's, like we actually know this, when you crowd the internet, it's there a lot. So this type of techniques actually doesn't address those issues. And also
clean it first. Yeah.
Right. But then the cleaning, actually, people have done a lot of work in the space. Cleaning data itself, it's a nightmare. It's a huge challenge. So that's why this type of technology, first of all, the problem is different than copyright problem, and it doesn't really help right now solving the copyright problem. So we do need to develop new methods to
So
address those.
I'm going to open to the crowd. I want one last question, which is more of my interest. Okay, so you're now working for OpenAI for 2 years. You have your own company. Let's say that there are these amazing procedures that academics or the research community proposes that will address privacy, copyright, and so forth. And let's say these companies say they do it. How do we actually verify that? I mean, there's this basic trust, which is misplaced in my opinion when money is involved. Anything to say about that?
I'm gonna put Scott on the spot here. I open source all my code and all my models. So if you want to check, my data sets are available on S3 buckets and you can download them right now. What are you doing?
I'm not going to speak for OpenAI, but
No, its verification could be a process that maybe you can the public can verify, even though it's internally done.
I mean, presumably, if someone sues a company, then these things will come out in discovery. Right?
I was thinking more about verification and as a downstream.
I mean, it's not I don't think either of these are very satisfying answers right now, and I wish I had a better way to do this. It is so easy to hide things in a model and so easy to put trapdoors in models that will pop out at weird moments when you don't expect them, or to poison models in various ways. The verification would have to be something more fundamentally computational, that you can verify every step of the computation that I perform to get to a model. And there's some really cool work on this that I've seen coming from Yoshavit's been working on this for a while and has some cool stuff at OpenAI. But I think it's still in its infancy right now. It kind of gets to broader questions of just trusted computing and whether you can verify the operations that were performed, especially when you're performing this much computation. It just seems like a tall order to me, to be completely frank. And anything that costs you a little bit of efficiency is costing you tens of millions of dollars. And if it's a voluntary thing, I want to do what's right, but if it costs me that much money, is it really worth it? It's a fair question.
It's governance, yeah.
And also, I think the community can develop, even though it may be a black box process, but there are various methods we can develop to evaluate the final property of the models and so on. So, for example, there have been great work done in the space of auditing differential privacy for these models. and so on. So certain properties, I think, may be easier than others to verify. So for example, if you embed a backdoor in the model, like there is no good method to do that. But for some of these other properties, I think they're interesting methods.
Great discussion, and now I'm going to let questions. So I think Anand is first, actually. Here's a.
Yeah, so great talk and interesting panel discussion so far. I want to come back to this question of metaphors that you raised as being really important. And sometimes it feels that some of us who don't understand the law sometimes hear things that seems like it's almost a religious purity law type of metaphor. You know, like, oh, is this thing clean or unclean, right? And it seems that like, you know, does it have the, but what you seem to be describing is that's not the metaphor that the law uses at all for thinking about it. And so did I catch that correctly? Was one question. And the second is, you mentioned this issue of like how equations and the expressive content of something versus the kind of idea, or this just you're describing something, this is the nature of the world. I mean, what are you going to do about it? And sharing that with other people, kind of from the perspective of copyright law. How is code different than clothing in this regard, in terms of functionality and sort of you have to do something this way? Because it seems like I heard that clothes are not copyrighted, and code is also trying to do something. So is this something that's been well worked out, or is this again a question of dueling metaphors?
So, except for computer programs and architectural works, things where there's an intermixture of expression and functionality, they're just not protectable by copyright law at all. That Congress made a choice to extend copyright to computer programs, to extend copyright to architectural works, even though there's an intermixture of expression and functionality. And so what happens, instead of saying, this isn't protectable the way that clothing isn't protectable, you say, it's protectable, but it has a narrower scope of protection because all the functional parts are not within scope of copyright. Now, what are the functional things? Oh boy, people like to fight about that. The Google versus Oracle case is a good example where the declarations that Google used in the Android platform, from standpoint of Oracle, this is highly creative expression, right? There were lots of choices when Java was first developed. There were lots of different choices that you could have made, and you know, Sun made this. We acquired Sun. Those are our intellectual property rights now. That's highly creative. And hey, Joshua Block, you even said it's so artistic, you know, so elegant. From the standpoint of the court, it looks functional because it facilitates interoperability and cross-platform utilities, and therefore is not within the scope of copyright. So we fight about these things all the time, but again, some part of what I've tried to convey here today is that the law is very backward-looking, right? It's like, I have this little pile of things that we've decided before, and I'm going to reach into that thing and pull out the thing that's the closest analogy to stuff that I know about already. It's very hard for courts basically to say, this is a case of first impression, and I'm just going to make it up, like what is the right answer, right? I'm going to do my best to approximate something that balances the interest right. But that's why the metaphors and cases involving technology in particular are very, very helpful. So software is another subject that I have spent a lot of my life on. And so I've been grappling with this since 1983.
So Anil?
So I have a question based on something that Scott said earlier. You had talked about how when humans go into a library or when we read books, and then eventually almost everything we do post that ingestion of information is going to be influenced by what we ingested. And LLMs are doing something similar. So how is it any different? I was wondering, like, unless I am ingesting pirated editions of information, either I have paid for those books or I've gone to libraries which have somehow bought those books. So the producers of the content have been compensated in some way. But and to me, the question seems to be that LLMs are at this point, the training data has been acquired in ways that are not compensating the producers of that information. And so is that something we should be worried about, or is that how we should be thinking it? Yes, LLMs might be doing something very similar to what humans are doing, but in one case, there is some way of compensating the producers of information.
I don't think that's necessarily true, though. OpenAI paid Shutterstock some untold amount of money to license the data. Shutterstock puts a large chunk of that money into a fund to go back to the content creators. So I think it's, it varies on the application and how much. In images, for some reason, people seem to like to take care of the creators and pay them, and people are good about suing. In text, we seem to take everything for free. There seems to be two different cultures there, depending on what kind of model you create. But there are certainly a lot of places where OpenAI and Meta's got a similar agreement with Shutterstock, and I think Google does as well, where actually the creators do get compensated.
Yeah, so I'm neither a lawyer nor a business person, right? So, but speaking personally, I would like, creators to get, compensated for how their work is being used, right? But, I think, there's another consideration that I think is very important, and I hadn't heard it yet, so I want to throw it out, right? That we all want language models to not hallucinate so much, right? We all want language models to not be spouting racist invective, right? Or to give sort of sound and helpful information. Well, how do you get that, right? A central way is by training them on high quality data rather than random crap that you find on internet forums, right? And where is that high quality data? Well, a lot of it is locked up in copyrighted books, for example, right? And so in some sense, for purposes of AI safety, like that is the data that you want to be training on, right? And so that's why I am fervently hopeful that a solution can be found that gets fair compensation, but that also allows that data to be used in training. Yeah.
So one thing actually that I didn't emphasize, but I think is important here, is that a lot of the data that this stuff has been trained on was put voluntarily on the internet, okay? And web crawling is something that's been happening for a really long time, and nobody's actually really, except for the field case, nobody's basically said, oh, that web crawling by itself is copyright infringement. So there's got to be, a balance here. Now, if there are these pirate sites which have these high quality books, and you train on those, that's a place where it's a little dicey. But it doesn't seem to me that that if I'm a graphic artist and I put my work on the open internet, I know that web crawlers actually make copies of it. So, but I think what we're seeing is, yeah, I put it up on the open internet, but I didn't expect this. Okay, and that's part of the sort of concern there. So, but if you could come up with a good compensation scheme for training data, that would really be a good thing.
Yeah, adding to this, I think also we talked about earlier, one difference we are seeing here is with this new technology, certain things become much easier. So for example, here, previously, this copyright materials, so if you have some pirate sites that has copyrighted material, if the site is not very popular, if not many people go to the site, then in general, the people don't care because the impact is very small. But here, it doesn't matter whether your site is popular or not. The model, by crawling the internet, will be able to get this copyright material, and then we'll be able to train it. For the model, it doesn't actually matter. It doesn't care whether it crawled from a really popular parasite or an unpopular one. So I think that's going to be a big challenge going forward as well, is that we don't even know, right? Like as long as you train model from crowd internet, you don't know where these copyright materials, where the violations has happened. And I think that's going to be a huge challenge.
I want to get in one last thought. I mean, Pam, I feel like I have to play Paul Ohm for 30 seconds. It's my legal obligation. I mean, what you just mentioned sounds a lot like a kind of contextual integrity to me, that there was kind of an unforeseeable purpose for using the data. The data is being used outside of the context for which it was put online. We've been talking almost exclusively about copyright law this entire time because we have one of the world experts with us. I'm kind of curious if there are other bodies of law we should be thinking about invoking here as we try to make sense of this. And I have to bring up privacy again as my legal obligation. So I'm curious to, maybe that's a good way to close with kind of a broader looking view.
So copyright has a little bit of privacy in it. So there are certain kinds of private things that you do that copyright just doesn't reach. And if you, let's say, have a diary and you keep your diary and then someone takes your diary and exposes it, copyright can actually essentially protect your privacy in that kind of way. But very often, these bodies of law kind of live in different places. And and this is not the first time that that people have tried to use the law to stop certain kind of web crawling. Okay, so there was a time where there were some lawsuits called trespass to chattel. Right, the idea that computers are basically personal property, and companies own it, and somebody uses that network and uses your computers, and therefore is trespassing on your property. And that was actually like a theory that people kind of went crazy for, and then people said, no, that just doesn't make any sense at all. And then there was the Computer Fraud and Abuse Act, right? That you were kind of exceeding authorized use. And so the High Q case that was before the Ninth Circuit recently was based on LinkedIn. Basically said you're exceeding, right? I gave you access as a user, but the user terms of service means that you can't scrape the site for data that you want, and so you exceeded authorized access, and therefore you are liable under this law. And the Ninth Circuit said no. So whether there should be some sort of regulation, whether it's the copyright tool or some other tool for when is web scraping sort of a fair use, or when is it sort of socially beneficial and therefore good, or whether it should be like, regulated, can be done for this purpose but not for that purpose. Maybe there needs to be a conversation about do we have the right tool kit for this? And that's a good question.
So I think we're out of time. I just wanted to we're talking about terms of service. So I just read that on August 3rd, the New York Times changed their terms of service to say that specifically they disallow any software program, including but not limited to training a machine learning or AI system to use their material. That's a big one. New York Times. Speaking of sources that we actually trust, what do people in the industry probably trust?
Violating a term of service isn't necessarily
Protection.
Anything other than a breach of contract.
And we also have historical web scrapes before the terms were changed.
Yeah.
Right. Okay, thank you. This was a tremendous, thank you very much.